A very warm welcome to lesson number 18 in our 50-part series on the law of evidence. In the previous part, we studied section 7, and before that we saw section 6. We understood section 6 and section 7 as being parts of res gestae. Section 8 is also an extension of that concept. Let us look at what section 8 has to offer in today's lesson. So we'd seen that section 8 describes to some extent the principle of res gestae, right? Although it is something that's primarily associated with section 6, but we also need to understand that section 7, 8 and 9 and a few others, which we will discuss eventually, also incorporate this principle. In case you haven't seen the lessons for section 6 and section 7, make sure you click on the I button here and watch that lesson first. This lesson is a little advanced and therefore would require your patience. Before we dive into looking into section 8, we need to know as to what section 8 does. So we again remind ourselves that section 8 is a section in chapter 2 of the Act. What does chapter 2 do? It tells you as to what facts are relevant and what are not, right? So section 8 is one of those sections that allows the evidence for certain collateral facts to be made admissible so that evidence can be given for it, so that evidence for it becomes admissible, right? So always remember section 3, which is the interpretation clause, it gives you the definition of what is relevant. And then remember section 5, because section 5 tells you that evidence can be given only for facts in issue and relevant facts. So what section 8 basically does is that it makes certain facts relevant so that evidence can be given for it. Alluding to section 6 and section 7, you see what they do is that they make certain facts relevant. Now, how do they declare certain facts to be relevant? Well, in law, it is done by the use of words, right? The words and their ordinary grammatical meaning signifies as to what the contents of those sections are, right? So section 6 gives you the word transaction. So when you have to remember section 6, you essentially remember it as giving you the word transaction. Likewise, when you talk of section 7, then the words that you need to remember are occasion, cause, effect, opportunity, state of things. I've explained this in the previous video. Make sure you watch that. Now let us have a look at section number 8. So the title of section 8 uses a few words, and that is the hint as to what you could expect in section 8. It talks of motive, preparation, previous and subsequent conduct, right? So let's look at it part by part. Let me first show you the first part of section 8. It says that any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. So what we'd seen was that we start off with the trunk of the tree. The trunk of the tree is what we identified as the fact in issue, the principal fact, the factum probandum. And then we branch out to the collateral facts that also need to be relevant, right? So now for section 8, it makes the collateral facts relevant if they are found to show or found to establish either the motive or the preparation. Of course, there's more to it, but for the time being, we're just seeing motive and preparation. Let's take a closer look at this now. When we talk of motive, preparation, and previous conduct, let's first talk about motive. Now, we'd studied in substantive law. Let's take, for example, the offense of, say, murder. Now, do you look into the motive of the offense as an ingredient of the offense? You do not. Instead, you look at intention, right? So you remember the term mens rea, which is the mental component, right? The guilty mind. Now, the guilty mind is assessed in terms of intention and not the motive. Therefore, it is important for you to remember that for pinning the culpability in substantive law, you don't look at motive, right? So motive is seldom important in substantive law. However, in the laws of procedure and especially the laws of evidence, motive plays a very important role, particularly when you are required to rely upon circumstantial evidence. Now there's this principle, this axiom, which says that look for whom the crime profits, which means that we look for the motive. Who is the person who profits when the offense takes place, right? So the investigation process also happens in the same way. So the police officer looks for the person who might be benefited. So therefore you're looking for the motive, and the motive might lead you to the person who is actually guilty, right? So remember that motive becomes important when you don't have direct evidence. Now, what do I mean by direct evidence? Let us say somebody sees someone stabbing someone else, right? So you've seen that A is stabbing B to death, or that was recorded on a video camera. So that is established. Now you don't need to look into what he might have wanted to do, whether there was any previous enmity or anything of that kind, because motive is insignificant when we have direct evidence of the occurrence. However, when you are relying on circumstantial evidence, evidence about the circumstances surrounding the matter in issue, then you require motive to come to your aid, right? You require the facts that suggest a motive, a malice, an enmity, or something of that kind to come before the court so that the determination can be made. Now, how can evidence for that be given? Evidence for that can be given only if those facts showing the motive are made relevant. And that is what Section 8 does. It makes the facts indicating motive relevant. Now we advance to our second term in this section, that is preparation. Now, what is preparation? Try to recollect this thing that we'd studied in substantive law. You remember what we understand as inchoate offenses? Inchoate offenses are incomplete offenses. Offenses that could not be taken to their end. Offenses that could not achieve fruition, right? Therefore, they are inchoate or incomplete offenses, right? So preparation is a stage where an offense is said to be inchoate. It's not been completed, right? So now what are the stages? You know that everything starts with something in the head. It germinates from a guilty mind, which is the mens rea. The next step that you take is the preparation for the offense. Thereafter, you go for what is known as the attempt, right? So the attempt is the stage that follows preparation, but still it is inchoate. And then finally, of course, you have the fourth stage and the final stage, which is the actual commission of the offense. Now, when we talk of preparation, it's important for you to know that preparation is seldom punishable. There are a few cases in which preparation is punishable. I want you to mention that in the comment section. Have a look at the IPC and tell me as to which those offenses are for which preparation is punishable. However, you'd realize that such provisions and such offenses are far and few between. The norm instead is to only punish the attempt, right? So preparation as such is not so significant in terms of the substantive law. And why I'm asserting this is because I want you to understand and I want to emphasize the fact that what we study in substantive law does not find itself applied in procedural law in the same way, right? So like we saw previously, motive, which really does not mean much in substantive law, holds a lot of significance in procedural law. Likewise, preparation is something that is significant in procedural law for the same reason. When you are looking for circumstantial evidence, when you have nothing that directly shows you that somebody has actually committed it or attempted it, then you go back one stage. You look at the preparation. What did he do around that? Did he go and get some guns? Did he get some knives? Did he have some? Did he take some steps in order to kill that person? Was he calculating the distance? Any of those things? Did he draw a map? So you see, all of these things, they're not a part of the substantive offense. However, they help you to get some facts through which you can decide as to who the person guilty is, right? Therefore, you need to know as to how preparation has been done so that you can find the person on whom the guilt can be pinned, right? And for that, Section 8 makes facts relating to the preparation also relevant. Getting to the third word. The third word is this word. Now, with relation to this word, are you thinking of electricity, that to conduct electricity, conducting electricity? No. When you say conduct, this is conduct, which basically means behavior, right? So Section 8 also makes relevant some facts that reflect behavior. Well, behavior of certain people in certain situations, right? That's what is made relevant by Section 8. It talks of the behavior of certain people in certain situations. Let's go ahead and take a closer look. Well, as we look at Section 8, we've already seen this part here. And now I want to draw your attention towards the second part that deals with conduct. So take a moment, pause the video now. It's important for you to pause the video. Try to read this and make some sense of it. As you can see, this is a little long, and therefore I want you to spend some time trying to comprehend it and trying to understand as to why this is so long. As I always say, The length indicates that there is some meaning, because no provision is needlessly lengthy, right? So if you condense it, if you shorten it, you are basically leaving out some meaning. So that's something we don't want to do. Pause the video and read this for a moment. So let's see whether you've been able to gather some meaning from what you just read. Okay, so when we talk of conduct, the first question, whose conduct? Are you able to identify that? Second, in what situations? When? And third, in reference to what, right? We're talking about the behavior in reference to a certain subject matter. So what are those? Well, I will not answer them for the time being. Go back, read it again, and see if you've been able to answer it. All right. So as you can see, this part of section 8 is basically one long sentence that might be hard to comprehend, and therefore I've broken this down into a couple of fragments. Let's see as to what is there in each of these pieces. So the first bullet point talks about the conduct of somebody, right? So it talks about the conduct of somebody. Then you have an and, which means that it will talk about someone else. And means that you're adding it. It's not an option, unlike or, the conduct of somebody and somebody else. So it says the conduct of any other person. Then it goes on to say is relevant. So it makes the conduct of certain people relevant. Okay. Now that conduct should be one that is in some way connected with the fact in issue or relevant fact, which means that it is influenced by or influences the fact in issue or relevant fact. So basically what this means is that the conduct cannot relate to something remote, something distant, something unconnected, right? So that's why it's a part of res gestae, because when you're talking about res gestae, then you're talking about things which are connected to the fact and issue and the matters surrounding it. Okay. Now, once that is satisfied, it does not matter as to whether that conduct was previous or subsequent. You can appreciate that preparation, for example, is something that happens only previously. Preparation is a kind of conduct, right? It's a kind of behavior, but that is previous. So you can see the word conduct widens the scope of section 8. As you can see, conduct is a really wide word. It enlarges the umbrella and the scope of section 8, okay, because it includes both previous and subsequent conduct. However, it is limited by two things. First, as to whose conduct has to be seen. That was the question that I asked previously. It has to be the conduct of the party or his agent, right? That's the first thing. The second is that it is also limited by the fact that the conduct should be in some way related to the fact and issue or the relevant fact. To give you a little map of what has been seen in section 8 until now and to identify the words, we know that there are basically three words: motive, preparation, and conduct, which could either be previous or subsequent. So if you find these words, in action, then you know that that fact has been made relevant under section 8. Simple. Let's talk about motive in a little detail. You see, motive is a psychological fact. I hope you remember that fact, as defined in section 3, contemplates two kinds of fact, right? The first kind of facts are those which can be perceived by the senses, which are the physical facts. And the second is a state of mind, a mental condition, which we understand as the psychological facts. So motive is a psychological fact. Now what the implication is that you cannot have direct evidence for motive. Let me give you an example. Let us say somebody harbors some enmity in his head. Can you have a photograph of that enmity? Can you have a witness of that enmity? No, you cannot, right? Therefore, the evidence for psychological facts would almost always be circumstantial, right? So motive requires circumstantial evidence to be given, and therefore section 8 makes motive relevant. All right. So you'd find that there are numerous illustrations that follow section 8, right? Now, I will discuss a few of them with you, and then I expect you to look at the remainder by yourself once this lesson is done. We will discuss two illustrations that relate to motive. Have a look at the first illustration, illustration A. What you can see here is that there is a motive because of which A has murdered B, right? There was something that he's done wrong and he wanted to hide that wrong. So he had a reason to commit the offense. Remember that this reason or the drive or the motivation to do something is not the intention, right? It is the motive. So in this case, you can see that there's the motive. So if evidence is given to suggest this motive, well, that is relevant. So basically here, the facts that are given here suggest and indicate the motive, and therefore they are relevant. Okay, let's look at another example, the illustration B. Now, illustration B tells you, in fact, I'd like you to pause the video and read it once by your own self. I assume that you've done so. Okay, so what you can see here is that B needed money, right? If B needed money, it means he would do something to get that money. That shows you a kind of motive. So now the fact that he was in need of money, well, many people need money. Perhaps I need money. Perhaps you need money. But in this case, we are looking at somebody who has defaulted, right? And now this default is the fact and issue, right? We are looking at that as the matter before the court. Now, the fact that he needs money is something that in some way influences the fact and issue. You'd agree that it influences the fact and issue, and therefore it is made relevant under Section 8. I hope you are able to appreciate as to what kind of facts are made relevant under the heading of motive under Section 8. Alright, now we look at a couple of illustrations for preparation. Let's have a look at illustration C. Now A is tried for the murder of B by poison. Now B has gone to procure this poison. Well, that is his preparation. Now buying poison by itself does not mean anything, Perhaps you could have bought poison because you wanted to kill an animal, or you just wanted to stock some poison with you. Well, there are many reasons for it. But when there is a certain offense that has been committed, now you're looking at preparation. And therefore, these are the circumstances surrounding the incident, and therefore evidence of that is made relevant by Section 8 under the heading of preparation. Let us look at another illustration. A certain document, whether it is the will of A or not, right? Read this by yourself and in for the motive. Okay, now we look at the illustrations relating to the word conduct. A is accused of a crime. Okay, the facts that either before or at the time of or after the alleged crime, A provided evidence which would tend to give the facts of the case an appearance favorable to himself, right? So he tried to fabricate things to make it look like, well, he's not done it, or that he had destroyed or concealed the evidence. Now, what are these two things indicating? The first is his conduct previous, before the commission. He made some arrangements so that it looks like, okay, A has not done it. That's his conduct, that's his behavior previous. Then you look at what he did afterwards. He destroyed or concealed some evidence, right? That is his subsequent conduct. And all of these things are made relevant under Section 8, right? This basically reflects the conduct previous as well as subsequent. Let us look at another illustration. A is accused of a crime. The facts that after the commission of the alleged crime, he absconded or was in possession of property or the proceeds of that property. You see, all of these show that he tried to run away. If he's absconding, you can draw an adverse inference. Remember this word, it's a nice thing. Adverse inference, right? Adverse means that something is not favorable. So when somebody behaves in a certain way, you can draw an adverse inference, an adverse presumption about that person. There is a section in the Evidence Act that talks about this adverse presumption. I'd like you to tell me as to what that is. It's not anywhere close to Section 8, right? Let me give you a hint. It is in the hundreds. So just mention that in the comment section. Anyway, so what we have here is that an adverse inference is being drawn, right, from this thing. That is circumstantial evidence, right? The fact that somebody has run away is a circumstance that is surrounding the actual commission of the crime, right? So that is also made relevant by Section 8 in terms of conduct. Now, if you had looked at Section 8 closely, then you would have seen that in addition to the body of the section and the illustrations, there are two explanations. Just have a look at these explanations by your own self first. I will not explain these to you. See it for yourself and try to make some sense of it. Alright, so I hope you had given it an attempt. We will look at some of it together and the rest is left for you as an exercise. Okay, if you look at the first explanation, it makes a distinction between a statement and conduct, right? So you remember that we are dealing with conduct and not statements. So explanation 1 gives you an explanation. What it says is that the word conduct in this section does not include mere statements, right? So mere statement is not conduct. However, if a statement is accompanied by some acts or gestures, well, then that thing could become conduct. So what you understand is that a bald statement, a mere statement, does not amount to conduct. That's what's essentially given in explanation 1. Go ahead and read it more closely. You will get more from it when you read it more and more. For the time being, I think enough has been said. Now let's look at the illustration that pertains to this explanation, right? So you have illustrations for each of the words and you also have illustrations for the explanation. It is important for you to know that the illustrations are given to in some way explain what is given to you in the body of the section, right? So you should be able to identify as to which illustration is given for what, right? So let's look at the illustration that is given for the first explanation. So the question is whether A was ravished. Now what ravished basically means is it's a synonym for the word raped. So the question is whether A was raped. The facts that shortly after the alleged rape, she made a complaint relating to the crime, the circumstances under which and the terms in which the complaint was made are relevant. So if she goes and makes a complaint, right, it is relevant. Just keep this with you for the time being. If it is relevant, it means it is conduct, right? What are we trying to see here? We are trying to see here as to whether something is a statement or whether it is conduct, right? If it is relevant, you know it is conduct and not a statement. Because if it had been a mere statement, then it would have been not relevant. However, here it has been declared to be relevant, right? The section says here that they are relevant. It means that these statements that she makes in her complaint are conduct, amount to conduct, right? Let's look at the later part of it. It says, the fact that without making a complaint, she said that she had been ravished is not relevant under the section. Now you see, when she says without making a complaint that she had been ravished, this is a mere statement, right? When you actually go and complain, well, when you complain, do you complain to the police? Just let me know in the comment section, right? Anyway, when you complain, you're doing more than simply making a statement. You're going to an authority. Also, who is the authority you go to when you have to go and make a complaint? Let me know again in the comment section. Anyway, what I mean to say here is to clarify the distinction between statement and conduct. When you go and complain, then you've done more than simply making a statement, right? So as we saw in this explanation, mere statements are not relevant, but if they are accompanied by something else, well, then that amounts to conduct and becomes relevant under section 8. Alright, moving on. Let us look at the illustration to the second explanation, right? This you should do by your own self. I will not do that for you. In the comment section, let me know as to which illustration number corresponds to the second explanation. Give it that time, give it that attention, give it that practice. Reading this section will not only help you with this section, but also with the art and the skill of reading provisions in general. There are very few sections that will allow you to do this. Section 8 is one such provision. As I said, this lesson was meant to be a little challenging, and therefore I will leave you with a question. It's a simple question, it just requires you to be a little aware. When we see the body of the conduct part of section 8, it says the conduct of any party or his agent, right, in any suit or proceeding. Now, what is the significance of suit or proceeding? I think you're already clear that suit refers to something being a civil matter, and you use the word proceeding generally to connote that things are happening in a criminal matter, right? When there is an offense, okay? Now, look at the second part of it here. Again, it talks about the conduct of any person in an offense. Now, when you're talking of offense, well, that is talking about criminal. Now, I have always told you that the law does not repeat itself, right? Redundancy is not something that you see in a provision, which means that if what I said was true, this would be introducing something new, right? Now, when criminal cases have been spoken of already here, my question to you is, what is the new thing? Who is the new person who has been introduced in this part of the section? I'll repeat the question for you. Here, you see that the provision talks about the conduct of parties, right? In any suit or proceeding, which means that it contemplates both civil as well as criminal matters. Then there's an and then it talks about someone else, another kind of person whose conduct becomes relevant. My question to you is, here it appears to be talking about offense, right? And offense is talking about criminal, which has already been discussed here. So what is it that is contributed? What is the new thing that has been given by this part? Let me know in the comment section. I hope this lesson was of use to you. Thank you so much for your patience. Good day.